And with that, I would love to bring on Jeff Green, our CEO of Cal Nonprofits, to give a little bit of background on the organization and get us started. Take it away, Jeff.
Great. Thanks so much, Robert. And thank you all for joining us this morning. This is probably more timely than we even wanted it to be, but we're delighted that folks have taken an interest in this. This morning, I think what I'm going to do before I introduce our panelists, and we have some of the true experts in this area to talk about what this all means for us as a nonprofit sector today. But what I want to start with is really just the brief history of the Johnson Amendment. And if I could see you all, I would probably ask by a show of hands how many folks had heard of the Johnson Amendment before about 6 months ago. It's not uncommon for very few hands to go up, and that's all changing right now. But in what we do with respect to the Johnson Amendment and associated issues, for those of you that don't know Cal Nonprofits, we are really a couple of things. We're a policy alliance and advocate for the sector. So we do a lot of policy and advocacy work, and I would say this work that we're discussing today sort of fits both in this category and the next. We are an educational resource for the sector, and that means a lot of webinars these days. Before the Zoom era, of course, it was a lot of conversations in person and community, and we actually do both now, including an annual policy conference. And then data and research. And when we find good data and work that have been done by colleagues, we like to push it out and make sure folks have access to it. And in areas where we find there is very little, we sometimes go and work with research partners to do that ourselves. An example of that would be our Causes Count report, which we've done several versions and iterations of, and actually are in the midst of an update right now. So stay tuned for that. But if you're new to Cal Nonprofits, welcome. If you're not, welcome back. We are a membership organization, so my only pitch today will be if this is of interest to you and you'd like to join us, there is power in numbers, and we are always happy to have new folks join for whatever reason in the alliance that we have. So let's go to the next slide here. So this is what we're talking about today. And I'll just say, Johnson Amendment it feels like a wonky in the weeds kind of a thing, and that's because it really is. But it's sort of like the air we breathe is how we think about it. It is so ever present in everything we do in the 501c3 public charity world that we just don't think about it. Most people are educated pretty early on that you cannot be a partisan actor as a 501c3 nonprofit. The problem is there's also a lot of miseducation, assumptions, confusion, and I don't have to tell, I know many of you, that we spend a lot of our time at Cal Nonprofits actually helping people understand what the real rules are, and in many cases helping people unlearn what they think they may have already learned. We engage heavily in policy work, in setting the rules of the road, and in how public policy and budgets are set. That is absolutely the role and purview of 501c3 public charities. We would argue that it actually has to be central, especially at times like this. But what we can't do, what that firewall truly is partisan politics, candidate electoral politics, and that all goes back to the Johnson Amendment, which was first passed in 1954, introduced into the Internal Revenue Service, into the tax code. And that Johnson, and you see him there on the screen, is the same one, LBJ, Lyndon Baines Johnson, back when he was a senator from Texas in 1954. He was the one who brought this to the floor and ultimately got it into the code. You see there on the left a favorite cartoon of ours, just sort of showing what we now really accept the Johnson Amendment to do, and that is sort of a protection and a firewall between partisan politics and the nonprofit sector as a whole. And there are reasons for that. I would argue that what it does for us is really protect each from the other, not unlike, you could make some kind of an analogy to the separation of church and state here. Allows the partisan political world to operate and allows the nonprofit sector to do its work. And in many descriptions of what it does and why we support it and why it has been so very much a part of our rules and regs for now 71 years, is that it really keeps the nonprofit sector out of the partisan world. And that helps because it allows people to engage with human services and other organizations in the nonprofit sector without having that to be polluted, you might say, by partisan conversations. Now, that's the theory behind it. Let's go to the next slide. It is not new to, we say this is largely uncontroversial, bipartisan embrace. In fact, there was only one change ever made to the Johnson Amendment, and that was in 1986 during the Reagan administration, and that was simply the addition of the wording or in opposition to. So it was long said you can't be acting in favor of and support of candidates or parties. Now it was that or opposition to. Really just an additional few words, not a change in type. But there have been many threats over the years and challenges to it, many of them coming from faith organizations. And we were just chatting before we started here today that some of us can remember back into the 1980s at least having these conversations. So I want to kind of talk about two kinds of challenges or threats to the amendment briefly here. The first was, again, really related to religious organizations that were preaching politics from the pulpit. And the most organized version of this really kicked up in the 2010s. This was the Pulpit Freedom Sunday initiative. It was from the Alliance Defending Freedom. And this is based on the fact that many religious leaders over the years had certainly preached politics, and they had not been challenged. There had been no enforcement actions generally. And so they saw, those who wanted to get rid of this prohibition saw an opportunity to actually basically go on the offensive and do sort of a dare campaign, if you will. So, film or record themselves preaching politics from the pulpit, send it to the IRS and say, we dare you to do something about this. And of course, not really a surprise, the IRS almost never did. And that emboldened this effort further. So that's one way that this has been challenged. So if you want to trace back the history of the challenges, a lot of it is religious organizations wanting to feel free to preach politics and partisan politics at that, often around candidates and their particular policies. Let's go to the next slide, if you will. And then last year, we had sort of a new type of threat to this. And this was an organization that was really created solely for this purpose. And I have to give them credit. One of the best acronyms on record, Safe Space. And this is an organization that filed for 501c3 nonprofit public charity status. It is an acronym for Students and Academics for Free Expression, Speech, and Political Action on Campus Education. That is Safe Space. And what had happened was the IRS had not done its duty to give an answer within a particular time frame. They filed a suit in federal tax court, something that most people are relatively unaware of, and that was last March. And so the theory was that if they were granted C3 status, that could undo the amendment right there and then. And then more recently, what's really made the news and brought this back to the forefront is the National Religious Broadcasters versus the Commissioner of the IRS, the case that is being talked about with a couple of churches in Texas. You're going to hear more about that today. I will say as an overlay to this, I first learned of the Johnson Amendment back in probably the late 1990s, working in sort of progressive nonprofit campaigns and having to get very clear about where that line was. I had never heard a national figure utter the term Johnson Amendment until the 2016 election, when then candidate Donald Trump started to speak about it. And this is all connected to some of these other challenges we just mentioned. So some may remember at the National Prayer Breakfast, I believe early 2017, he said, I think the quote was, we're going to totally destroy the Johnson Amendment. So things like that started to pop up in the national conversation. And that also was new. So here we are, and we have a couple of cases, and we have a robust debate. We have a First Amendment question, and of course we have a massive nonprofit public charity sector, all very much paying attention to this now for the first time really in quite a while, maybe you could say historically a greater number of us than ever. So with that as prelude, I would like to introduce some folks to you. Before I do, thank you, that slide. This is one I proudly stole from one of our partners, Alliance for Justice. I want to just say that this is the map we often use when we talk about what the Johnson Amendment really means. And you see that one partisan political left-hand prohibition, that red light, that's the one thing that it's really here to block. Everything else is about types of advocacy or lobbying, and there are rules about that. But when we're talking about the Johnson Amendment, we're really just talking about that one big prohibition. All right, thank you to the Alliance for Justice. And here's a list, we'll put this back up probably at the end. If you want more about how you can engage in this work, because this is so much core to what we're here to do, Boulder Advocacy and Alliance for Justice is there. The Internal Revenue Service itself actually has some pretty clear things right up there on its own website. Our colleagues at the National Council of Nonprofits, our colleagues at Independent Sector, and you're going to hear from Ben today from IS and what their role is, and of course, good old Cal Nonprofits. So, all right, with no further ado, We have some fabulous folks that have been swimming in this deep water for many years. We have Ellen April, who's a senior scholar in residence at the UCLA Lowell Milken Center for Philanthropy and Nonprofits, and a regular fixture of many a conference. Many of you may have seen Ellen or heard Ellen in action, so we want to welcome her. We have Daryl K. Jones, who is a College of Law professor at Florida A&M and writes one heck of a blog. And if you want to read Daryl's thoughts, you can access those generally anytime, day or night. And then we have Ben Kershaw, who I just referenced, with our colleagues over at Independent Sector. He's the Director of Public Policy and Government Relations at Independent Sector. So please give a big warm welcome to our three presenters, and we're going to hear from them in that order. So thank you all. I'm going to turn the mic over to Ellen and mute myself. Thanks again, everyone, for joining us.
Hello, everyone, and thank you for including me. Here's the language of the Johnson Amendment again. That no 501c3 is allowed to participate in or intervene in, including the publishing or distributing of statements in any political campaign on behalf of or in opposition to any candidate for public office. Like Jeff, I never called it the Johnson Amendment until now President Trump did. Part of the problem, it's really hard to do a shorthand of this phrase, and the Johnson Amendment is a handy shorthand because people talk about it as political activities. That's too broad. It has to be someone, a person being elected to public office. One of my friends say, ideas good, people bad, which is a pretty good shorthand. And it's for elected office. So I often tell people, if you elect your dog catcher, Johnson Amendment applies. And we have seen a fair amount of activity around school boards of late in terms of the Johnson Amendment applying or not. So what we have had happen is that two churches and then the religious broadcasters brought a suit in Texas saying that they felt constrained from doing what they believe in endorsing candidates by the Johnson Amendment. This case had a long history. At one point, the plaintiffs wanted to invalidate the entire Johnson Amendment for any kind of C3. It then, on both sides, got narrowed to just houses of worship. And what we have currently is a proposed order from both the plaintiffs and the government. The government in this case is the Department of Justice, not the IRS, because it's in district court rather than tax court. We assume and are quite sure that the Department of Justice lawyers consulted with the Internal Revenue Service before they issued this proposed order. Again, let me emphasize, it's a proposed order. The judge has not said whether he will accept it, whether he will modify it. There was just last Friday, Americans United for Separation of Church and State filed an amicus brief pointing out what it saw as issues in the proposed order. So if we can go to the next slide. So even though it is a proposed order, it has been covered broadly as if it is a new enforceable rule, a new statement of what the Johnson Amendment means to the IRS. So National Public Radio says churches can now endorse candidates. Washington Post, IRS says churches should be allowed to make political endorsements. New York Times, IRS says churches can endorse candidates from the public. Again, what we have is a proposed order. I would also emphasize that it really focuses on direct endorsement, saying from the pulpit, we support, you should vote for, we oppose, you should not vote for a particular candidate. The Johnson Amendment is broader than that. It includes indirect intervention. Perhaps one good example of indirect intervention would be bringing one candidate, but not the other main one, to speak at some event. And that could happen for other 501c3s besides churches as well. Again, these headlines are not accurate as a technical legal matter, but it is having considerable impact. And we think it may presage an announcement from the IRS, either in a statement as to the rule or as to enforcement of it. So what I want to do is examine the reasoning of the proposed order. Again, we don't know that the judge is going to accept it. So here is what it would say. This is what their last statement is, that the court would hereby enjoin the defendants, IRS, from enforcing the Johnson Amendment against plaintiff churches. So the order is just the two churches, not the national religious broadcasters, based on speech by a house of worship to its congregation in connection with religious services through its customary channels of communication on matters of faith concerning electoral politics viewed through the lens of religious faith. So almost every word in that proposed order raises issues. So if we could go to the next slide. So part of what the proposed order says in the reason that they are criticizing it is that to participate in a political campaign is to take part in the campaign, and to intervene is to interfere with the outcome or course of it. And they cite a 2025 dictionary, which may or may not be good for something that goes back to 1954, but they also take a very narrow view of what these words might mean. Participate, to take part. I don't know how endorsing a candidate or opposing one is not taking part. And intervene, to interfere, I don't know, what does that mean? You stop someone from going to the polls? It is such a narrow definition of the word. We can find much broader definitions all sorts of places. And the language that says, including distributing pamphlets, really suggests that intervene is far broader than interfering. So their very narrow understanding of the statutory language, I think, is problematic. And I also think if that's the position they are in fact taking, I don't know why it wouldn't apply to any 501c3 and not just to houses of worship. Next slide. They also, and I think everyone's a little taken aback by this, say that bona fide communications internal to a house of worship between the house of worship and its congregation in connection with religious services do not participate or intervene any more than does a family discussion concerning candidates. We are all a little astonished by that comparison. My mother, may she rest in peace, had a very large cousins club, but I guarantee it did not amount in the hundreds and did not amount in the tens of thousands the way that many of the mega churches do. I don't have any dispute with members of a congregation having discussions among themselves, but if they have their leader, their minister, or other clergy do something from the pulpit, that's more than a family discussion. And I would draw the analogy that if a family forms a family foundation, it gets 501c3 status. In that role as officers of that family foundation, they could no longer say vote for or vote against a candidate. So that one part is very problematic. Next slide. They also cite Supreme Court precedent very selectively. They cite a very recent case involving the Catholic Charities Bureau and a Wisconsin government entity. But that statute was so different. It specifically talked about a particular way of religious practice. That case went into why the Catholic teachings would permit them to qualify. What we have in the proposed order doesn't really explain why the churches feel they have to endorse or oppose candidates rather than speak about their values. The proposed order does not cite two free exercise court cases that are very important. So Texas Monthly v. Bullock said you couldn't have a sales tax in Texas that exempted religious publications, that if it applied broadly, that was fine. And Employment Division v. Smith is a pretty famous case involving someone getting dismissed from a government job because he participated in religious practices that involved peyote. Clearly was a religious practice. And a famous Justice Scalia opinion says if a provision is neutral on its face, then religious organization, including houses of worship, have to live with it. It doesn't discriminate on its face, but we see no discussion of these cases in the proposed order or the memo supporting it. Next slide. There are so many unanswered questions about the proposed order. What are customary channels of communication? What about sermons that are shared on web pages of the house of worship that anyone can come to? What about virtual worship? I looked at the largest mega churches. The largest was 76,000. The next largest was 45,000. A synagogue I know, it was during COVID at their Day of Atonement service. Apparently, they had 600,000 people watching that service. And we are very concerned about gaming. Entities created as churches to take advantage if this is a new rule. Churches do not have to file for exemption, unlike other 501c3s. They do not have to file annual information return, the Form 990, so we don't get information about their political activities, whether lobbying or campaign endorsement. And there are particular rules called the Church Audit Act in the Internal Revenue Code that the IRS has to follow before they can examine something that a church does. Next slide, because I'm about to turn it over to Daryl. We know that the IRS has not generally enforced the Johnson Amendment against houses of worship. So part of the question is, what will the practical effect of this proposed order be, whatever happens in the case? And I'm going to let Daryl talk about how he sees those issues.
Daryl, I think you're on mute.
Sorry about that. Thank you, Ellen.
Gotcha now.
I always do that. Anyway, in terms of how the law might be applied going forward, I think Ellen mentioned that Americans United for Separation of Church and State filed a motion to intervene, and then in the alternative, they were denied the right to intervene or the ability to intervene. They asked to be allowed to file an amicus brief. And the court has already granted them the right to the right to file an amicus brief, and the parties are still arguing over whether they should be allowed to intervene. I think they're going to lose on that. But in their amicus brief, this is what Americans United said. They said, and while this decree nominally applies only to the two plaintiff churches, the IRS would be hard pressed to argue that other houses of worship cannot engage in similar conduct without opening itself up to future lawsuits. I mean, this is so timely because not only do we have this litigation with national religious broadcasters and the churches, but we also have some case law about universal injunctions. I mean, the Supreme Court just a couple of weeks ago basically ruled that universal injunctions are the exception and not the rule. Right. So, and you know what? That opinion it's Trump v. Casa, and it's 120 pages long. I mean, it's ridiculous. But at least we have one group, one well educated group, Americans United, who feel like this proposed order, if it's adopted, is going to lock the service into a national policy or national approach or national litigation position. And Ellen is quite right that this is a very bad way to make national law through a litigation between just two parties. It's very bad. And who was it? It was Phil Hackney up at the University of Pittsburgh a few days ago described how this might be done properly. A notice of proposed rulemaking, comments, and then a hearing, and then consideration, and then finally a well thought out rule, regardless of which way it comes out. But just to emphasize that at least both parties think that they are litigating a national policy. This is what the government said in its brief in opposition to AU's motion to intervene. The government said the proposed consent judgment simply recognizes, based on statutory text, settled interpretive principles, and the IRS's long-standing general treatment of the Johnson Amendment, that the Johnson Amendment does not reach a narrow category of speech. Now, they're calling it a narrow category, but as Ellen pointed out, if it's narrow, it's very ambiguous. I mean, speech by houses of worship to its congregation in connection with religious services, blah, blah, blah. And so nominally, the case adjudicates the rights of just two churches. But, if you think about the attorneys in DOJ and Chief Counsel's office, I mean, these are serious people without necessarily access to grind, and they in their jobs. I mean, I know a few of them. I have some former students who work in Chief Counsel's office at least. They really try to get it right. They try to not only apply a statute, but also to comply with the Constitution. Now, it's true that the parties have sort of incorrectly cited another Supreme Court case, Catholic Charities versus Wisconsin Labor Bureau, and I think Ellen has covered it. But the case stands for a proposition that's relevant to this discussion. It basically says that the government may not have a rule or policy that in effect allows it to give preference to one religion over another. And so it seems to me that once this proposed consent is signed, if it is ever adopted, the IRS will be locked into a nationwide position, because who in DOJ or IRS Chief Counsel is going to say, well, we have this one rule for these two particular churches, but we're not going to apply it beyond those two particular churches, even though that really is technically the outcome because of the Supreme Court's jurisprudence on universal injunctions. One thing I love about nonprofit law is that it's the only part of the tax code that allows me to be a part-time constitutional scholar as well. And Ellen is good at that too in terms of the First Amendment stuff. But let me just also add what the plaintiffs said in opposition to the AU's motion to intervene. This is what they're saying. I gotta find it here a second. It says, here's what the plaintiffs say. It says, the order is limited to what churches and other houses of worship say in their worship services using their normal means of communication. All that this proposed consent decree does is to remove the opportunity for disparate treatment and eliminate a chilling effect on churches. I mean, they're speaking generally about what the proposed consent order is going to do, and they're talking as if this is going to apply to all of the church, all churches who are engaged in their normal means of communication. So I am really of the opinion that, you know, whether it's a legal mandate or a practical result, the consent order is gonna establish national policy. And again, this is a very, very poor way of establishing national policy because the parties have different interests in terms of settling stuff. They're not necessarily trying to hammer out the best policy as a policy matter. They're just trying to win the case on either side. Now, the government, I don't mean the government is just trying to win, but they want to get the best outcome as well. But the plaintiffs are just trying to, you know, they're not necessarily bringing in all of the different views that might be expressed by different stakeholders. And one such view that might be expressed is kind of, I guess it's coming out, it came out yesterday or the day before, where you had Americans United, Cal Nonprofits, and a bunch of, and what the headline I read said that 1,000 nonprofits have written a sign-on letter to the president asking him to back off of this position. And one of the primary concerns that they raise, I think Ellen's talked about it briefly, is that, you know, once this consent order is signed, if it is signed, it's going to open up the door for sort of the use of organized worshipers to funnel campaign contributions. One other thing I want to say about Americans United petition or their amicus brief, they kind of raise the issue of, you know, of this is a poor way to make law. They say, you know, while the parties strive to portray the proposed consent decree as regulating a quote narrow, clearly defined category of speech, the reality is far more ambiguous. To begin with, it is unclear, and then they talk about all the ambiguity. It's unclear what precisely is meant by speech by a house of worship to its congregation in connection with religious services. And then they ask some rhetorical questions. They say, does this language cover any person connected with the church or just the faith leaders? Is this language limited to oral communications or can it also include written communications? Can these communications be broadly shared on the website, in a newsletter, etc.? Or must they be confined to conversations that occur within a congregation? Now, the plaintiffs, I guess the plaintiffs are really being represented by national religious broadcasters. They say in their brief in opposition, they say, I think this is significant. I just got to find it on my notes here. They say this proposed consent order forecloses churches from taking out ads. I mean, I don't know that it really does that, but that's what the plaintiffs are saying, at least. That's how it says, well, I've already summarized it, but I do agree, though, that regardless of what the plaintiffs are saying, you know, and who knows whether this consent order is going to be, you know, published in an FSUP or not at all. But the plaintiffs are saying, no, the plaintiffs and the government are trying to portray this as a narrow sort of ruling when in fact there are just too many, as Ellen pointed out, the language in the language that implements the permanent injunction has speech by either of the two churches to their congregations in connection with religious services through customary channels of communication on matters of faith concerning electoral policy. So that's 6 different, you know, points that you'd have to meet. And of course, if you had an aggressive church that really wanted to be involved in political communications, we probably would see a billboard on the interstate saying, don't vote for this candidate or vote for that candidate or you'll go to hell, you know, something like that. And then they would argue, this is our customary channel of communication, and you, Mr. Government, may not judge us on how we decide in exercise of our religious beliefs what our customary channels of communication are. So I think that the point is well made that the substance of this, I'll call it a concession by the government, although I think there's a good argument that what they're trying to do, I don't know how well they do it, but what they're trying to do is simply to, I guess, codify through the judicial process what they believe is the longstanding approach. But of course, by injecting sort of these bullet points or the factors that have to be met, I mean, you're just open up the door for all sorts of litigation because lawyers or nonprofits, at least the ones who want to be involved in politics. And funny thing is, I don't think most churches want to be involved. I mean, they do it sometimes from all sides of the political spectrum, but they'd much rather not be involved because I think what they're afraid of is capture by one side or the other, and they don't want to be viewed as the Republican church or the Democratic church. I mean, we sort of think of churches as conservative and liberal anyway, but they don't. I don't think they want the explicit label of being a Republican-based church or a Democratic-based church. So those are my comments, and I really appreciate being here. I love this stuff. I'm such a nerd for this stuff, so I want to thank everybody for the invitation, and I will hand it back to Robert, and I'll let
Daryl,
him take over.
I so appreciate your comments, and I'm actually going to bring you back on. We have a little bit of time. I'd love to hear both you and Ellen have provided some really in-depth and wonderful academic discourse on this topic. And I wonder if we could have a quick discussion about the varying points of view and maybe distill it in a way for those of us that are less versed in the academic and policy realm, and bring it back down to say 5,000 feet for those of us that are less educated on this topic.
So I'd say there are concerns among houses of worship. So some of them want to do this, some don't. Some really fear division and pressure within their congregation. Imagine someone saying, I'm not going to give you this big donation unless you endorse my candidate. So there's fears of split among the congregations. Last time there was this possibility, many congregations signed letters opposing it. But true, some want to do it. There is pressure even for houses of worship that will stand firm, I think. There was one New York Times article on the New York mayoral campaign and how various people were pressuring various houses of worship to take positions. And the article speculated it could affect the outcome of the campaign. So there are those concerns about keeping houses of worship focused on worship and religious principles. And then I think another point that probably is very important to your audience, and that the Americans United for Separation of Church and State made, what are the arguments against a carve out just for houses of worship? What about the language and our current law, including constitutional law, says that houses, faith-based organizations can and should be treated differently from non-faith-based organizations, for which also are very committed to their own principles and matters of conscience, and either might want or might not want to do the same thing. So this introduces all sorts of different kinds of splits.
Yeah, I agree with all of those things, and I did read something a while ago by an author who asserted that, you know, faith-based organizations. Goes to Ellen's point that we ought to have a separate section in the code for faith-based organizations because they're involved with the First Amendment, unlike other just charities, hospitals, and educational organizations, unless those educational organizations are also faith-based. But that person argued that, the tax code doesn't exempt houses of worship. Houses of worship are exempted by the First Amendment, meaning, the power to tax is the power to destroy. The government can't destroy, and therefore they may not tax. I've never seen that really asserted in an official way, probably because, the United States and every state in the country exempts faith-based organizations. But there's some data. There's some data out. I saw this data right after the consent order was proposed that said something like 70 or 80% of congregants don't want their churches involved in politics. And this is a reputable organization. I forget what it's on my blog, but I think they say that in general. But in a particular election, congregants who are, like with branch ministries, they were so against abortion rights, and they came out and campaigned against Bill Clinton because he was the spawn of the devil, and he was going, and if you voted for him, you're going to go to hell, right? So I think that there's a disconnect between the congregation and in general, and then the congregation in any particular election. If the election is I don't know if it's accurate to say if the pastor is preaching hard enough, he can get the congregation to want to authorize his intervention. But look, the two things that are corrosive in life to any sort of relationship are sex and politics. I think that politics will end up being corrosive to houses of worship. I mean, we'll end up having houses of worship aligned one side or the other, and I think they will rue the day that those who want the freedom to do that will rue the day that they advocated for it, because that'll cause them to have to line up. And then politicians recognizing, that they have to take one side or the other will start implicitly or explicitly demanding favors, right? I mean, you want some zoning concession or something else, then endorse me, right? So I think as a practical matter, I wouldn't want it in my own house of worship, and I think but I don't know that the majority can prohibit it as a matter of national law. Although I think this consent order will do that, but only by the consent of the party currently in power.
So I think that even organizations that one argument would be, well, you don't have to do it. All this does is give you the permission to do it. But the pressure that these congregations will see, I think, is corrosive as a matter of policy. And it's always hard to balance the Establishment Clause and the Free Exercise Clause. I will point out that all C3s have the First Amendment freedom of association right as well. So they have First Amendment interest in addition.
That's great.
Good point.
Thank you so much, Daryl and Ellen. That's a great discussion, and I really appreciate the back and forth. I know that we could probably go on forever here, but I would love to bring on our third panelist. Ben, I'm going to share your screen and let you take it away and maybe bring us back down to earth, some of the implications and the real policy issues at stake here today.
Thanks, Robert. And, thank you to you and Jeff for having me and independent sector on today. I describe independent sector, to anyone who will listen as, well, we're like Cal nonprofits, but at the national level. And, in addition to the nonprofit community, right, our membership also is comprised of foundations and corporate giving programs that have, a lot at stake in this debate as well. So you've been treated to, I think, a really remarkable and insightful discussion from two, real leading scholars. And I say that not just as someone, sucking up, but as someone who's been in a lot of conversations about this case over the last few weeks, and who is not a lawyer or a legal scholar. So what I want to do today is to ground us a little bit in sort of three key data points that we are holding at Independent Sector as we look at this case and at this issue right now. And so the first data point I want to talk about is a national survey that Independent Sector commissioned earlier this year, working with a firm called Target Point, a Republican firm that has, they've since had a merger, but if anyone wants to work on polling issues, I highly recommend them. They're great to work with. And one question that we have tracked in surveys across the years working with this firm is public support for the Johnson Amendment. And as Jeff noted, you kind of have to explain what it is first. That has always been the case. It is especially true now that the Speaker of the House has the last name Johnson, and has a very different perspective on this issue, in fact, than Lyndon Johnson did. So when people are explained what the Johnson Amendment is, the overwhelming majority of them, 75% of voters, want Congress to keep in place this prohibition on endorsing candidates. And this is a number that has been pretty consistent across all the years that we've asked it. You don't see numbers this high in public policy polling very often. And what I think is also remarkable is how bipartisan this is. This is, 73% of Republican voters want to see the Johnson Amendment preserved. 69% of frequent churchgoers, right, upon whose basis the plaintiffs claim they're making this case. So the public support for this prohibition is deep, it is broad, and it is longstanding. So the next research piece that I want to share with you is more recent, and this is from another annual survey that Independent Sector releases. This one was released this month, working with Edelman Data and Intelligence, who are sort of the national experts on trust. And we've worked with them on a sampling of public attitudes around trust towards nonprofits and philanthropy. And it's really rich data. There's a lot of questions that are asked throughout this. And I'm happy to share kind of the full report with folks for later reading. One, I think key thing that we start from on this issue and on many other issues is that the nonprofit sector's most valuable asset is public trust. And we've said that for a long time. And in the last few years, we've been able to measure it. And, depending on your screen resolution, you're looking at 14 columns here. And the dark green is people who have high trust in that segment of American society. So 57% of Americans in this survey reported having high trust in nonprofits. That is not just the highest of the 14, but it is, really significantly so, right? 12 percentage points higher than the second ranked institution in this chart. I try not to make fun of legislators too much by pointing out that they're all the way on the other side, right? That the federal government is in the teens for high trust. And, as we think about what a proposal to repeal or weaken the Johnson Amendment would be, you're essentially mixing the right end of this chart with the left end of this chart. And I think we know what that would do for the sector. We know not just as a matter of, guessing, but because, this year, this survey actually dug into this issue in a little bit more depth. So on the next slide, I want to talk about another aspect of this debate, which is, shockingly, Americans think that our nation is too divided right now. And there is one segment of American society that they feel is working to unite us rather than to divide us. And again, overwhelmingly, that is the nonprofit sector as compared to businesses or the media or the federal government. So we have a lot at stake here, and people are looking at our sector as a unifier and not a divider. So I'm glad, Natalie, this is inspiring until we get to this next slide. So you will see in this question specifically about the Johnson Amendment that was asked. If we can go to the next slide. Americans are asked about attempts to weaken the Johnson Amendment. And when they hear about the Johnson Amendment's existence, it sort of reaffirms, I think people's general sense of what our sector is, but upwards of 40% of Americans across all political persuasions are more likely to trust nonprofits when they hear about the Johnson Amendment. And again, for people who already knew about it, that's likely to have no impact, right? So 40% is a pretty strong number there. Similarly, when people hear about efforts to weaken it, they are less likely to trust our sector. I don't know that any of this data is sort of shocking or counterintuitive, but it is, we still think it's really, really important proof. And Ellen, I think, did a good job of laying out, and Daryl too, some of how people might approach the idea of nonprofit organizations endorsing candidates. And that's borne out not just by esteemed legal scholars, but by these average voters whose quotes you see here, right? And so people intuitively understand that nonprofits and charities are going to be under pressure to endorse candidates so that they can either get help from elected officials themselves or get donor money. They, conversely are concerned that people and voters will follow the endorsements of charities who they're relying on for basic services. So this is, very much something that is on average voters, is a concern to average voters when you put it on their mind. The third key data point that I want to talk with you about, I don't have on slides, and it is this concept that that Daryl noted about money flowing to campaigns through charities, campaign money essentially becoming tax exempt and therefore becoming subsidized by all federal taxpayers. And again, this isn't merely a legal argument. It is borne out in a table from the official accountants in Congress. The Joint Committee on Taxation assessed a proposal in 2017 that would, let me pull up the legislative language here because I think it'll rhyme if you've been, seeing Ellen's slides about what's in this proposed settlement. So in 2017, legislation passed the House of Representatives stating that an organization wouldn't be violating the Johnson Amendment if a statement was made in the ordinary course of an organization's regular and customary activities, and if it didn't incur more than a de minimis cost. Right? That sounds a lot like this judgment. And that proposal, that section of a bill was scored at costing the United States Treasury over $2 billion. And that means, right, those are newly charitable deductions in lost, right, and that's lost revenue. Meaning that even if you assume everybody making those donations is in the top tax bracket, you're looking at $6 billion over 10 years flowing into our elections and being tax subsidized through the charitable sector. Right, you saw polling numbers. The only way you could get higher numbers, more unanimity, is if you ask people if there was too much money in politics or not enough money in politics, right? This is a subsidy for campaign ads. And that's from 2017, just like the editorial cartoon that Jeff showed you earlier with the moat, right, of the Johnson Amendment protecting our sector. So if you're concerned about this, and I think a lot of us are, there is something you can do. And Daryl noted this earlier, and we're really grateful to Cal Nonprofits, not just for signing on to this letter in support of nonprofit nonpartisanship, but for sharing it out with this network. And we know many of you all have been engaged. Independent Sector, the National Council of Nonprofits, Interfaith Alliance, Public Citizen, a number of allied groups that have long worked together to defend this part of law we call the Johnson Amendment, are leading this letter. There's over 1,000 signatures on it now, and the deadline for people to sign is August 8th. So we're grateful to those who've signed it, and we hope others will. So why don't I stop there and turn it back over for questions.
Thanks so much, Ben. That's a great way to bring us back down to earth and give some of the practical implications of the order. I'd also like to bring Jeff back on for some final points before we head into Q&A.
Thanks, Robert, and thank you, Ben and Daryl and Ellen. There's so much we can talk about and cover here, but I really appreciate the perspectives and the knowledge you all bring to it. Two things really that I neglect to say at the front end, I think are of historical note and sort of relevant context. First of all, there is no evidence that Senator Johnson did this for any high-minded reason. So if you go back and look at the committee notes from the 50s, it appears that the very likely impetus for him to propose this amendment was that he'd drawn a primary challenger who had significant resources and deep pockets, and was operating through some nonprofit advocacy organizations that were quote unquote anti-communist at the time. Now remember, this is height of the Red Scare, so political context also matters a lot here. Although it has resulted in what we all now can celebrate, that moat and that sort of protection of the trust, that certainly was not the intent at the time. So just an interesting note of where these things can come from. The second is something that several of our panelists actually referenced, and that is, this is connected to other efforts. And when it comes to transparency, I think Ben just said that if you really want everybody to agree to any opinion, you can say get money out of politics and you're likely to get nearly the entire population on your side. And there are lawsuits right now still ongoing. Some may remember the Americans for Prosperity versus Bonta in California, which was challenging the notion that we had to disclose our largest donors to the state. Well, Schedule B still exists on our 990 forms, and the Buckeye Institute has been suing to get in opposition to that. So if we were to see that lawsuit be successful, which is that further obfuscating and eliminating what has to be reported to the IRS, and then allowing partisan political donations to flow through C3s, we would be in a whole different area. So there's a lot at stake here in addition. And I just wanted, those were referenced, but I want to sort of tie those pieces together. But thank you, Robert, and thank you to our panelists.
That's great. Appreciate those thoughts, Jeff. We do have some questions in the chat, and I'd like to facilitate a quick Q&A session with our panelists here. And I'll start from the top. And the question is this: do the endorsements of political candidates include financial contributions and verbal endorsements, or just one or the other? And the other question being, there have been political figures that attend church services and speak from the pulpit for years. Is that illegal?
I'll let Ellen go first.
So there's always a hard issue about incumbents, and the prohibition doesn't apply to incumbents speaking as such, and that can be tricky sometimes. There was a case with the NAACP that was, was criticizing President Bush, and for some reason the IRS came after them. So he was both a candidate and an incumbent, and they were able to show this was what they'd been doing all along. This was no different from their taking positions about his incumbency. When the IRS did do a political activity campaign initiative in the mid to late 2000s, they did find churches and other C3s making direct contributions to candidates. I don't think this order would go that far, but that's part of what's unknown. If we support as a religious organization people who do what we believe in, maybe they could argue that it was one of their customary channels, even though one point I did want to make, that our whole system avoids, tries to make sure that all political contributions are taxed at least once. There are all sorts of rules that make sure that that happens, and this would be a big change to that rule.
Yeah.
I agree. I don't think that this proposed consent order would uh, condone, passing the hat and making a love offering, as we call it in some of our churches, to a candidate who happens to be there that day. But I do think though that it's almost as American as apple pie, that every 4 years the candidates show up at various churches. And the funny thing is they usually sort of do some church hopping on Sunday morning. They'll show up for 15 minutes at one church, and then they try to reach all the churches that they believe represent their voters, and they're here to worship, not here to campaign, but they're really there to campaign. I mean, let's not be silly about it. And I just think that this consent order has. I mean, sometimes they don't even the candidate's not there to speak, although they might be asked to share a few words. But the pastor, at least in the churches that I've attended over the years, is going to introduce the person and talk about all their great things and not mention the other side. And just one other thing, and maybe Ellen can because she has her memory is better than mine and her experience is better than mine. But there's lots of IRS guidance out there about what constitutes political speech. I remember when I was a university counselor, we had to research whether a group could invite a candidate to campus for a rally, and whether that would imply endorsement if they didn't allow their places to be used by other folk on the other side. But I'm not so sure that there's a whole lot of written guidance about what can and cannot be stated in a church service. I just think it's not out there. Maybe you know a little bit better, Ellen. I do think that there was a proposed statute some time ago that specifically addressed speech connected to churches, and it tried to somehow carve out, but I don't, the English language is so ambiguous. I don't think that could really be accomplished.
I think
That
that's
makes
what Ben
sense.
was speaking of. Originally, that proposal was going to be just for houses of worship. And the proponents were told, no, it's not good, or maybe not constitutional to distinguish between churches and other C3s, and the language back then got broadened.
That's a great follow-up. So, Ellen, I've got another question here that it dovetails right into this conversation, and it comes from Anne. And Anne asks, lots of talk about churches, but what about most nonprofits? What impact does this have?
So what we see right now says no to other nonprofits, including other religious organizations that are not houses of worship, which is pretty interesting in terms of how far the proposal goes. And I think that's one of the basis for attacking it, that not everyone is religious, and distinguishing between those who are and those who are not raises difficult issues as well. Now, it's true when the IRS did this political activity campaign initiative, it did find violations of churches, but of other nonprofits as well. It's not uncommon to misunderstand, particularly the indirect campaign intervention. And I don't think we want the IRS to be out there enforcing footfalls, but it is a slippery slope.
Yeah, and that slippery slope also tails into a question that Mary has, and I'll read it here. And she says, I don't know about others, but one of the grave concerns with such efforts to destabilize or weaken existing nonprofit law is the fear that the IRS will be weaponized to strip nonprofits arbitrarily of their 501c3 status based on perceived lack of compliance with the president's agenda, as many of us losing our NEH grants this spring. So I recognize this isn't the primary topic of the discussion today, but I think it is important for us to touch on.
Yeah, you know what, I would have maybe 10 years ago, I would have said, oh, you worry too much. But I don't feel that way anymore. I think that the current administration is aggressive. They're not at all shy about beating society over the head, or at least that part of civil society that doesn't agree with their views. I mean, take DEI, for example. I mean, they are really going after colleges and universities, and they're going after transgender athletes, and I mean, it's just it. I don't think that is a spurious concern. I think that's a real concern. I never would have thought of it. I still can't believe we are where we are, but I think that's a legitimate concern.
Daryl, would you
Amy,
speak to the groups that help the undocumented? Because you wrote about that recently.
That's another good example. I mean, even the Congress is now holding some of the subcommittees or committees are holding hearings about these radical leftist nonprofits, and in one hearing they even named the U.S. Catholic bishops as a potential conspirator in the illegal immigration trade, and then even Vice President Vance. He was kind of chastised by the Pope because he said, "Oh well, the Catholic Church is supporting immigration because they're making so much money out of it." So there is some cynicism out there, and that's a great example of how if people can, they would weaponize the service and the Department of Treasury against their. I mean, really, what they're doing is they're fighting against free speech. I mean, civil society is simply the organized expression of our constitutional rights of speech and religion and so forth.
Ben, any final thoughts to add before we wrap it up here?
Just that, I think especially in light of some of the legislative environment that, Daryl notes and that I spend most of my time swimming in. This is one particular settlement and we can debate its impact, but it's certainly not, it's far from the last word on this. Again, I noted earlier that, Speaker Mike Johnson has been really clear that he would love to see, this part of law repealed. So, folks will need to stay informed, stay engaged, and they're well served with Cal Nonprofits doing all that.
And thanks so much for also dropping the link to the lettered reference into the chat. As I noted, I'll be sure to include that along with our recording, PowerPoint, and all the references or the resources that we've referenced here today. And with that, I would really like to extend a very hearty thank you to all of our panelists, Ellen, Daryl, and Ben. This discussion has been very informative. We covered a lot of ground today, and I appreciate the ability for us to both get into the weeds of this order and this issue, and then also to discuss some of the more practical and day-to-day implications that we see flowing from it. In addition, I'd like to thank everyone who attended. It's really important and especially inspiring to see so many folks signing on to these webinars. The interaction in the chat and the engagement between our communities and our different nonprofits is really important as we move through this time together. So thank you so much for registering for this event. And we look forward to having you at future Cal Nonprofits events.